Let me introduce Jordon Rolfe. Jordon?
Well, thank you. Thank you for coming. I'll give you a little bit of just a brief background. I am actually from Salem. I grew up in Salem, went to Smash Fork High School, went to BYU Law School, and then my family and I moved to Arizona for about 6 years, where I worked down there in the corporate litigation department of a Phoenix area law firm. We've been back here now for about 2 years, and it's good to be back here in Utah. We live in Salem. The law firm I work for is actually in Pleasant Grove, but I try to focus my efforts here in this area of the valley where I know a lot of people and then try to do a lot of work down in this area. I'm happy to be a member of the Spanish Fork Salem Chamber of Commerce. Today, the kind of the idea behind this was it's a similar presentation to one that I gave in Phoenix to the Chamber of Commerce there, and hopefully it can benefit you business owners. A lot of times, in my experience, I've found that small business owners, they go through the process of creating a business and an entity of some type, and then they kind of let the formalities go by the wayside, and a lot of times that opens them up to personal liability and issues that can hurt them down the road. And I have a slideshow here. It's not too exciting. Most people who've ever talked to an attorney probably would not ever say that there was much exciting going on. In Utah, and this is probably pretty general throughout the United States, but the most common types of businesses are sole proprietorships, partnerships, limited partnerships, corporations, and LLCs. And I presume that probably those of you who are here have one of these types of business entities. While we're going here, I would like to say if anybody has a question while we're going through it, just go ahead and ask the question. You don't need to wait till we're done. I would like to have some dialogue if there's a question or anything that you had about that. The first three, sole proprietorships, partnerships, and limited partnerships, carry significantly more risk to the owner of the business than the last two. And I'm going to go. What I'm planning to do is kind of go through the characteristics of each of these, kind of tell you where there's some risk, and give some tips and pointers on things to help you avoid risk. Sole proprietorships are the most common form of business entity. It's because it's the easiest one to create. Generally, it's just somebody who goes out and starts doing business. Someone who does a lemonade stand is running a sole proprietorship. There's a lot of risk for that. They're 100% responsible for the debts of the company, all liabilities, torts, contracts, anything like that. The owner is liable for all of it. It's basically an extension of the owner. The main characteristics of a sole proprietorship is that it's great because the owner gets to make all the management decisions. They don't have to have somebody else do that. They have all the profits. They also sustain all of the losses. They're personally liable for all the obligations of business, which is not a good thing. And they can lose everything if something goes bad in the business and with liability. Some of the good things about it, other good things, it's highly transferable. It's easy to switch ownership. The bad thing is it terminates upon death if you haven't got something in place to keep that going. So if you die, the business is done. If you have a family or kids who are hoping to take over a business and you pass away and it's a sole proprietorship, that creates problems. Principal source of capital is the owner and their creditworthiness, and typically their income is, well, it's always taxed as personal income. That's one of the good things, and that as you. About that. It depends on your situation, but yes, it
cost me a lot not knowing, and thousands of dollars in personal taxes when I went S corp, and it was less than half of what I paid a year for.
You're right, and that's why a lot of people have moved towards S corps with limited liabilities companies and corporations. So it depends on your situation, and I think most of the time it's not looked upon as a favorable thing. Most of the time you would look at an S corp situation. The reason that they're popular, like I said, they're easy to set up. There's no formalities. There's no requirements. There's no statutory requirements of things you have to do with a sole proprietorship. General partnerships, I'm going to kind of lump this together with limited partnership, which will follow, but a general partnership is two two or more people who are engaging in a business enterprise. You share in the profits, you share in the losses. If you don't have something in writing, then you share in the profits equally. If you don't have something in writing, you share in the losses in the same way that you do the profits. So if you have an agreement, a partnership agreement that says we're going to share profits 70-30, but you don't put anything about losses, you automatically will share in losses 70-30 as well. Again, like a sole proprietorship, there's liability to the partners in a partnership. There's not a lot of formalities to creating a partnership. In fact, there's lots of cases out there where people don't believe they have a partnership, but they're doing some things together, and then they're sued, and the court finds, yes, you do have a partnership, and you have to share in the liability of that partnership. So you need to be careful how you hold yourself out and represent yourself when you're doing any kind of business with somebody else, because it can be construed as a partnership even if it's not one. Partnerships can own property in their own name, in its own name, which is different from a sole proprietorship. They can sue and be sued in their own name. The partners have to sue in their own name. They can't. It's not the name of the partnership. However, if you do have a partnership name or you're doing it under another name as opposed to your own name, you need to register that with the state. I'm going to skip through a couple of these because we've covered a lot of them. Partnership agreement. If you have a partnership, you should always have a partnership agreement. I talked a little bit about the sharing of profits and losses. Partnership agreements are just like what any attorney will tell you. Anytime you do any type of a contract or an agreement, you should put it in writing. Because two people may be sitting in a room together talking about what the agreement is, and invariably, you both understand it differently. I can almost guarantee 99% of the time you understand it differently than the person you're talking to. So if you put it in writing, you're able to cover all areas, and then it's easier if there's a dispute of some type.
Hey, Jordan?
Yeah.
On the last slide, did it say partners cannot sue other partners?
What's that?
I missed the slide. I was reading the slide and you switched, and it said something about a partner cannot sue another partner. It was on the prior.
It was two back, I saw it too, but it went by fast and it may not sue his partner. There you go.
They can ask for an accounting, and then the formalities for suing your partner are different in a partnership than they are in an LLC or a corporation. And the first thing you have to do is, and I apologize because that's a little bit misleading because you can sue your partner. But you have to ask for an accounting first and go through a little bit different process. Limited partnerships are they're a partnership. The difference with limited partnership is there's a general partner and a limited partner, meaning that one partner does not have exposure to the personal liability. The general partner would have exposure to personal liability, whereas the limited partner would not have exposure if they follow some formalities. There are formalities for a limited partner. They can't participate in the management of the business. If they do that, then they are exposing themselves to a limited liability. But there has to be, for a limited partnership, you have to have at least one general and one limited partner.
Kind of an example would be the general would be the guy who runs the business, and the limited partner is the guy who funds it.
You're right, and that's the advantage when you're talking about a general partnership and a limited partnership. The advantage to a limited partnership is it's easier to raise capital because you're not limited to your own credit worthiness. You can say, hey, I'm going to run the operation and have somebody come in to fund it, and that person, now they are liable to the point of, to what their investment is, but they're not going to be liable if, you have a company truck that's driving down the road and there's a wreck or an accident, or liable for the contracts of the company or things like that. So yes, thank you, I appreciate that. Limited partnerships are created in accordance with state statute, so there are some formalities. I talked, one of them being that you can't, as a limited partner, you cannot participate in the management of the business. You still share in the profits and losses. You can agree to what degree the sharing is, but there still needs to be a sharing in the profits and losses of some type. let's see here. A partner's interest in a limited partnership is not as freely transferable as a sole proprietorship. Generally, when there is a transfer of membership interests, they don't. The person who gets the new membership interest does not have the same rights as the person who gave it to them. They're able to vote on. They're not able to vote on things. They're just entitled to the other person's share of the capital and assets. So if you're getting membership interest from somebody who is a member of a partnership, you want to make sure that you understand what you can and cannot do. And you know, sometimes you may get it and have no control over what's going on. You can't vote on anything, and that can hamper your ability to make any money. Okay, the last two are kind of the two that really are the beef of what the whole topic here is, and that's corporations and LLCs. Corporations have been around for a long time. They're the most common form of business entity. The thing that's great about them, as you can see, it talks about they can attain economies of scale, and that's because they're able to raise so much more capital than other forms of other business entities without subjecting themselves to liability. So corporations have been around for a long time, and they allow people to invest money and become owners without having the duties of management and the risk of liability. They're governed by statute. There's formalities, and we'll go through a few of the things you have to do to create a corporation. But a corporation is treated as a legal person and a legal entity. In fact, about a year and a half ago, there's a big issue with politics right now and the ability to raise money in these super PACs. And essentially, the court held that corporation is a person and you can't restrict its right to free speech. And that's kind of the basis for the issue of them being able to raise a lot of this money. And so they're treated as a person, a totally separate entity from the people who own it.
Like Mitt Romney said, corporations are people too.
That's right. But and a corporation can you know, in a corporation you'll have officers and directors. They can be shareholders of the company. They don't have to be shareholders of the company. At the bottom one here it says a shareholder has no right or duty to manage the business of the corporation, and that's not always the case. Sometimes the shareholders are the people who manage it, but in a lot of cases, big companies, you know, we may own stock in something, we don't get a say in how it works. Limited liability for shareholders, with the exception of the amount that they invested in it. It'd be nice if we could always know we were going to get back the amount that we invest in something, at least that amount. But other than that, they're not going to be subject to liability. Interest in a corporation is freely transferable. That's a plus, and you can step into the shoes and the same rights that the person who you purchased the interests from, or if you're just purchasing stock, there's obviously interests that you have with that are spelled out in the stock agreement. Shareholders have no fiduciary duties in a corporation. It means that I can buy stock in Sam's Club, we were talking about that earlier, and then I can go and work for Costco, and there's no concern there. Whereas a lot of times if you are a member of a partnership or an LLC, if you're the managing members, you're the people who run the business, there are fiduciary duties to the company. But if you're just a shareholder in a corporation, you have no fiduciary duty to your other shareholders or to the company. Taxes are paid different with corporations, and Jim brought that up just a few minutes ago. Generally, shareholders pay personal income taxes from the corporation when the corporation makes a distribution of the assets to them. And in the past, I don't know how many years it's been. Jim, what's your profession? Are you an accountant?
I'm an insurance agent.
Okay.
But I own many corporations.
I don't know how many years it's been since the subchapter S corporations and LLCs have been around. I think it's been about 20 years, about as long as LLCs have been around. So you can, depending on what kind of a corporation you have, you can be taxed a little bit differently, and the tax structure is more flexible than other types of entities. Corporations have what's called corporate formalities, and here's where we get into kind of some of the things that you have to do if you have a corporation. This applies to a degree to LLCs. There are things that aren't required but that you should do in an LLC, and one of those, you should have corporate bylaws. That's called the corporate formality. But it spells out what the officers and directors need to do. It specifies what they can't do, the time and place that the annual shareholder meetings will be. They make provisions for committees of the board, define their membership and scope of their activities. It's kind of like a contract that spells out what everybody's going to do. You should have that. It's a necessity to have that if you have a corporation. If you don't have that, it's easier for somebody to do what's called piercing the corporate veil when there's a problem, breach of contract, or...
Write it down because you're not- So I have to sit down with me, myself, and I and write all this stuff down.
There'll be a list in here that gives you a little bit, that's a little bit clearer as to all of them. Here's some things that you need to do, ongoing requirements for corporation. You file the articles of incorporation with the state. You need to have bylaws. Each year at a minimum, you need to have minutes and shareholders and director meetings, record those. Now, if your bylaws say that you're supposed to have monthly meetings, you need to be having monthly meetings, not just yearly meetings. And a corporation should have more than a yearly meeting. Keep track of the minutes. Keep track of the records, any resolutions that are adopted, anything that's changed, shareholder interests, most recent annual report, and all the financial statements prepared for the last 3 years are all things that if you have a corporation, you should be doing. If you're not doing them, start. Taxes are an issue that you have to address every year with corporations and LLCs. It's not like a partnership where it just you just pay your personal income tax. If you're going to open a business bank account, you need a federal tax identification number. And unlimited liability is different than a corporation. However, a lot of the things that you do that you're required to do with a corporation, you should be doing with an LLC for purposes of protecting yourself. And LLCs have only been around for about 20 years. Surprisingly, they were first used in Wyoming. Wyoming was the first state to adopt LLCs, and since then, every state has now adopted the ability to create an LLC. They're much more flexible than a corporation or a limited partnership. They're quickly becoming the entity of choice for particularly small to medium-sized businesses. You're not required to hold annual meetings by statute, but you should hold meetings and keep minutes and records in an LLC. The members of an LLC can participate in the management to a greater extent than limited partners. They can actually participate fully, but you need to be careful that you don't step into the shoes, a situation where they could claim that the LLC is just an alter ego of the owner. And they're just using that to put up a front. An LLC consists of one or more persons. We'll talk about this in a few minutes, but if you have an LLC, you should consider having at least 2 persons. One person in an LLC can be considered what's called a disregarded entity. And it's very easy, well, it's much more easy to pierce the corporate veil if you're a single owner of an LLC, because it's really easy to argue that you are just using that for your own personal benefit and you're just the alter ego of the LLC. So we tell people a lot of times you should have your spouse, that's the easiest way to do it, be a member with you. But you should consider that. The other thing is if there's a judgment against you personally, and you're the owner of an LLC, and you're the only owner of an LLC, it's much easier for creditors to get what's called a charging order and to come and get your interest in the LLC, whereas as opposed to a situation where, say, it's you and your wife who are the members of an LLC, they can still get a charging order, but they can only come in and get your interest in the company, and they don't really get your interest. What they get is your share. If there's a distribution made or something like that, they would be entitled to that. Now, the law as it stands right now, and it's changing in July, have you seen much with the changes in the LLC laws? There's going to be a lot of changes with the LLC laws. In actually LLCs, LLP, all of them, and they're all going to be different. In July, they will go into effect in Utah, but they become much more creditor friendly.
Can you explain the difference, the member manager at one LLC where everybody's a member manager and one where there's just managers?
In an LLC, there are two types. There's one that's member managed and one that's manager managed. A member managed LLC means that the members make the decisions. They're not running the high level stuff. Sometimes they may be running the day-to-day. Depends on your agreement. But the members basically agree between themselves when a decision is made. And a manager-managed LLC says that the manager has the right to make the decisions. Whatever you have in your operating agreement will specify, here's what the manager can do. And then the manager can make those decisions without consulting with the members. And whereas opposed to a member managed, the members would need to agree on that. Does that answer your question? A lot of times people, most of the ones I set up where it's someone who has just one LLC, a lot of times it's just member managed. Usually it's between them and their wife, or just them, but it's member managed. Whereas a situation where I have a client right now who has several LLCs and they're all under an umbrella LLC. All of the lower ones are manager managed, and the overarching one is member managed. And then they appoint managers for the ones below, and they do that to keep an arm's length transaction between the upper and lower. Because if there's some kind of liability with one of the lower level LLCs, you don't want that to reach to the top the top level corporation or LLC. I hope I'm even making sense and not talking circles here. This talks a little bit about what you just brought up, members, managers, employees. It's the management is reserved to the members or managers depending on what you've agreed on. And this is specified in the Articles of Organization that's filed with the state. In addition to the Articles of Organization, you should have an operating agreement. Even if you're a single member LLC, you should have an operating agreement. If there's ever a problem, you can show that you're abiding by the formalities. Even though it's not required, it's easier for you to say, hey, this should be kept separate from my own personal assets or my own personal liability. They are creatures of statute like a corporation and a limited partnership. There's guidelines that you have to go through. It has to be filed with the state. You have to reserve a name and make sure that all of that is okay before you can say that you're operating an LLC. You should also make it clear that you're operating an LLC when you're doing business. Put it on your business card, LLC. When you sign a contract, don't sign the contract in your personal name. Sign it Jordon Rolfe as manager of such and such LLC, and make clear that that's what it is. I had a client one time who had a $300,000 or $400,000 contract that he'd signed with the LLC, and there was a dispute that cost him, in attorney's fees, it cost him almost $100,000 disputing whether or not he signed that contract on his personal behalf or on behalf of the company. He didn't write on behalf of the company, and it caused a lot of problems.
So you have to write your name plus as manager of.
I would.
member.
Or just on behalf of. I would make it clear. If you're the manager, you can say as manager of such and such LLC. You can do it however you want. Whatever you do, I would make it clear that you're signing on behalf of the LLC. Now, the disadvantage is most of us who are small business owners, when we have an LLC, we have to probably sign personal guarantees to get funding, or maybe if you sign a lease, they want a personal guarantee with that. And so there is going to be some liability a lot of times, but you can limit it to a certain extent by making sure on certain things that you sign it as a representative of the company, not on your personal behalf.
Is it with corporations that make a difference?
I would still make sure that it's on behalf of the corporation as well. Yes.
Yeah, I never knew that.
There's nothing that says you have to do that. It's just an extra step that you can take to protect yourself. Because you don't want somebody to be able to say, I mean, even in simple cases, I had a dentist client who was sending all of this work to the labs every month to get dentures or bridges and things like that done, and they would just always sign it. And then there was a lawsuit, and there was an issue about, well, we thought you were signing it on just yourself. You weren't signing it on behalf of the company. You never said that it was on behalf of the company. Even though it may appear clear that that's what it is, an argument can be made, and attorneys are masters at making an argument out of nothing. Jameis especially.
Guilty to proven innocent. Oh, it's
So one of the main reasons for having a business entity as opposed to just doing it on your own is to protect your assets. Okay, that's why we do it. That's And now there are other benefits. With corporations, LLCs, limited partnerships, it's easier to raise capital and things like that. But you want to make sure that you're protected. And in Utah, there's a two-part test when we're talking about piercing the corporate veil that the courts have adopted. And it says that there must be such a unity of interest in the ownership that the personalities of the corporation, and you can put LLC in there, or individual no longer exist. The corporation is, in fact, the alter ego of one or a few individuals, and the observance of the corporate form, or some of the formalities that we talked about, would sanction a fraud, promote injustice, or an inequitable result would follow. Okay, so they ask these two questions, and then there's several factors that the courts look at, and these go to the things that you need to make sure you're doing. One of the big ones, the most common one that I see a problem with, is a commingling of funds, especially in small businesses. And that means that you use the same bank account, or you have two separate bank accounts, but payments are made and they go into your bank account and aren't forwarded into the company's bank account, or vice versa. But the funds are not kept separate. So you need to make sure they're kept separate. Now, that doesn't mean that you can't take a draw or even take a loan, but you just want to make sure that that's documented and it's just not a commingling of funds.
I have a case right now where the owners obviously are entitled to their salary or their dividend or whatever, but they just happen to be taking their payments every time their personal checking account was in the red. So instead of taking it on every 2 weeks, their payments as owners, their salary, whatever, if their checking account went, they're in negative, suddenly they transfer from the business account to the personal account $100 just to get out of the red so they wouldn't have overdraft. And you do that 5 or 6 times a month instead of having it set. Now,
Going through payroll or something?
yeah.
Well, I do it all the time. My CPA said there's something wrong with it.
Well, it just looks really bad if you're doing it, because it appears that the only purpose of the business account is an overdraft protection for your personal account.
I pay myself that way.
Right.
And then plus payroll.
Yeah, it's okay to pay yourself.
Yeah.
Just make it look like it's a systematic,
Oh, okay.
scheduled, a scheduled thing. Don't do it 10 times a month because you have to pay for this and you have to pay for that, and so.
Well, I do.
That's
I always have.
I'm coming after you.
Come as needed.
And that doesn't mean that you're breaching the corporate formality, but what it does do is,
And he's good. I mean,
it's not that you can't do that. It's that if there's ever an issue, then you're going to let somebody else make the decision for you as to whether or not you deserve to be protected or whether or not you're abusing the entity. And so it's not to say that someone can't or well, I won't say shouldn't, because we would advise you not to do it. It's not that you can't do it. There's no law that says you can't do it. It's that it raises this issue of, are you keeping yourself separate from the business?
he said as long as I had a payroll set up, I'm safe.
Yeah. Okay.
Yeah.
That should cover it.
Yeah, and just keep records so that you know that it's there, and it's easy to show if, hey, this is what I'm doing every single month. It's the same thing, as opposed to this month it was 5 times and the next month it was 10, and it became as needed.
The IRS looks at it.
Yeah.
And the thing that a lot of people don't understand, or maybe don't quite fully understand, is that if there's ever a lawsuit, it becomes very easy for the other side to get bank records, everything. There is nothing that you can't, almost nothing that you cannot hide. On a computer, if you've typed it on your computer, it's there. I have had cases where, I had a case where we had a forensic expert come in on the computer, and he found things that had been deleted 6 or 7 years ago that were deleted. He found what we needed. Now, it becomes expensive. Those are things that you don't normally deal with if it's not a huge matter. But for us, things that may not be a huge matter to a corporation are a big matter to us.
Right.
And so the records and things like that are important. Make sure you're keeping good records and accurate records. If you've appointed officers or directors or managers, and if it's an LLC and you have a manager, but the manager's not doing the managing, you are, that's a concern. Same with the corporation. If there are no corporate records, is it undercapitalized? The example I use on undercapitalization is the trucking company who opens without any insurance. Doesn't mean that you have to start a business, you have to have $100,000 in the bank. but you need to take precautions to make sure that the necessities are covered. And if you're going to be out on the highway with the truck, you need to make sure that those things are insured to protect the public.
Contract, like all the contractors that didn't have workers' comp, because it
These are things that you should be doing. Holding an organizational meeting, whether you're an LLC or a corporation. Corporation, it's more important. However, I think in today's world, it's becoming just as important for an LLC to do that, even if it's not governed by statute. Adopt bylaws or an operating agreement. Issue the stock in a corporation. Corporate records, make sure they're accurate. Hold regular meetings and keep the minutes of those meetings. File your corporate income tax returns. Make sure that the manager are involved. File your annual renewal fees. Anybody here ever missed their renewal fee? That's pretty common. I actually had a client who's in this general locale who missed their filing fee. I had a competitor come in and actually take the name, and then it's a huge mess. Now, they'll get out of it, but it's an expense that they otherwise would not have to have had to pay. And you hear people talk about, well, I'll get my attorney's fees. Well, the judge might tell you get your attorney's fees at some point,
It's
but
sad that they can allow that. I come from New York. In New York, there is no renewal fee. Once you're set up, you're set up, and there's no thing, and nobody can steal that name unless you do an authorization or sell it to nobody. Having something like that happen because the guy didn't either get a renewal or didn't come in the mail, I think that's...
well, and it's not necessarily easy to do that. You miss the renewal date, and in Utah, I think it's 2 years you have to wait before that name is available. So you've not only missed the renewal date, but you've let it go a long time down the road. So, it's not just missing a simple deadline. Yeah. So those are the main things that you need to be making sure that you do to make sure you're protected. Now, there's lots of other things, that really aren't related to this. For instance, wills and estates. You should have, I tell anybody who's married or has a child, you should have some kind of a will or a trust. But there's a lot of other things that you can do to protect yourself. If you're a business owner, however, the main thing to remember is make sure you're keeping yourself separate from the business. And that's especially and that's more, again, when we're talking about an LLC or a corporation, that's not so much the case in a partnership or a sole proprietorship, because you're on the hook with those. And if you are running a partnership or a sole proprietorship, you should consider creating some kind of an LLC or a corporation and moving that direction, because in today's world, I'm an attorney, so I make my money, dealing with the problems, but it's becoming very prevalent. The people who don't have a LLC or a corporation regret that they didn't have that. It's not expensive to create one. I think the filing, James, correct me if I'm wrong, but I think the filing fee with the state's somewhere between $70 and $100. And then if if you're a corporation, you need to have an operating agreement or bylaws, and you should with an LLC as well. And that's probably going to cost another few $100s to have an attorney do that for you. Now, you can do it on your own too. I don't recommend people pull something off the internet and do it, because a lot of times there's things that are missed, and later on it doesn't really serve the purpose that they thought it was going to. I'm talking about I'm talking about an operating agreement, the bylaws, or the documents that you use with your corporation. However, you can do that. You just want to make sure you're not missing things and that it complies with Utah law. Does anybody have any questions for me? Like I said, there's going to be big changes in the LLC laws. They're already, I have not looked in detail at them yet, but they're going to affect in July of this year. And they're creditor friendly, not owner friendly. They change the way that the charging orders, that's what I talked about, where if someone gets a judgment against you, the process for some of the things that they can do to try and collect. They also change, an operating agreement now can be oral when this goes into place, as opposed to in writing, which I don't know how, that's going to create more problems than solve. It is. It's not good for the business owner. So there are changes that are going to go into effect in July.
Has to have an operator, is that what
No, you don't have to have one.
In the past, if you didn't have one, there's a statute set up that these are the default rules. So if you don't have an operating agreement, the statute provides the default rules. But now, and it had to be, if it wasn't in writing, it was the statute. But now, under this new statute, if it gets passed, if it actually goes into effect, it's passed but hasn't been in effect, is that right?
In July, it goes into effect.
You could have an oral agreement. So if you have two members of your LLC, you know, a year later, you can say, hey, Dave told me that we would do it this way. And Dave will say, I don't remember that, but then the court has to decide.
Which again goes to why you want to put it in writing.
And you can change that law, change all those in the panel LLCs.
It will,
prior.
in 2 years,
That's what I wonder, because I like insurance, it's grandfathered in and you can't
it
change.
will be grandfathered in, but not for 2 years. So in other words, in 2014, they're going to make it so that everybody, it's the same. You can opt to join before that if you want to, or you can wait until 2014 and it automatically will be. But it cements the idea of you want to make sure you have records and you want it in writing. If you have something in writing, it becomes very difficult for somebody to say, well, we had this in writing, but my partner said this. You can't just introduce that kind of stuff. It makes it hard to do. So that's why you want it in writing.
So why an LLC over a S corp, or why an S corp over an LLC?
I would always, and S corp is actually, it's just a form of an entity. You can have an LLC that's taxed as an S subchapter in subchapter S, just as you can a corporation. I always recommend to someone that's going to be starting a small business or even a medium-sized business, most of the time an LLC is better. Your tax, it's pass-through taxation in an S corp, so you're only taxed on your income that you get.
I had a situation where I was setting up a corp through my CPA suggested that I do that, and then my attorney told me that I should have an LLC that would protect me better. Well, I says, you know what, you guys figure it out. So they talked together and my CPA won. He said my tax advantages were better with the corp than it was the LLC.
And that's, you should always,
That's what it was. Consult with both.
you should always consult with both. I don't give tax advice. I stay away from taxes like it's the plague. But,
Right, yeah.
so you do want to check with your
It was a whole lot nicer.
accountant. The difference though, outside of the taxing issue between an LLC and a corporation, number one, there's much less with regard to the formalities that are required in an LLC versus a corporation. The filing requirements are a little bit different. It's much more flexible than a corporation is, especially again if you're talking about a smaller business. And when I say smaller, I mean small can still in our eyes be pretty big. I'm just, if you're not AT&T or Microsoft or something like that, then it's a little different. But the LLC is a lot more flexible. It's easier for you to have a say in kind of what's going on without creating issues of liability in an LLC than a corporation. But the big thing is taxes, and you do want to check with an accountant and make sure, hey, what's going to be better in my situation?
Can you do distributions in a corporation? I think I've heard they have to be equal, but in an LLC,
Well,
a member or a manager could have more than another one. Distributions could be different.
well, they'd be different based on the ownership interest in an LLC and what the operating agreement says. In a corporation, it would be based on what your stock is, whether you have common or preferred stock and things like that. So there's a lot that goes into it. The one thing that you do need to know, though, is that when you're in a corporation and you're a shareholder of the corporation, you have no say in when a distribution is made. So they could not make a distribution even if you think that it should be made. Now that kind of goes into another issue of liability. I mean, if you're not making distributions because you don't want to pay your partners or things like that, that creates issues. But you have more say in an LLC. Especially, it depends on how you set it up, though. Again, they're very similar in a lot of respects, and a lot of that goes into what you have in your agreements. Anything else? All right. Well, I'm glad I could be here, and we're trying to do kind of a series of these things for business and for individuals. We're going to have one on collection strategies, and there was a list of 5 or 6 different things, but we're going to try to do 4 or 5 of these, hopefully, that will benefit individuals as well as businesses in the community. So Look forward to doing another, and I appreciate you coming. Thanks.
Thank you.